Three, two, one, start. In the statements of witnesses examined from either side, determinative factor is whether it is essential to the just decision of the case. Duty is cast upon the court to arrive at the truth by all lawful means, and one of such means is the examination of witnesses of its own accord when for certain obvious reasons either party is not prepared to call witnesses who are known to be in a position to speak important relevant facts, whereas this section confers a wide power on the court on summoning witnesses. The discretion conferred is to be exercised judiciously. As the wider the power, the greater is the necessity for application of judicial mind, whether the new evidence is essential or not must depend on the facts of each case and has to be determined by the presiding judge. Object is to bring on record evidence not only from the point of view of the accused and the prosecution but also from point of view of the orderly society. If a witness called by the court gives evidence against the complainant, he should be allowed an opportunity to cross-examine, since a witness summoned by court could not be termed a witness of any particular party, comma, court should give the right of cross-examination to the complainant, full stop. Section 319 Power to proceed against other persons appearing to be guilty of offense before exercising discretionary jurisdiction under Section 319 court must arrive at the satisfaction that there exists a possibility that the accused so summoned is in all likelihood would be convicted. Such satisfaction can be arrived at inter alia upon completion of cross-examination of the said witness for the said purpose. Court concerned may also like to consider other evidence. Full stop. Section 320 Compounding of case complaint under Section 403 and 120b. If the complainant wants to compound the case and the provision is there under Section 320, he should be permitted to do so. If the complainant does not want to proceed with the case also, it is not necessary for the accused persons to appear in the case since it is the complainant who has filed for compounding of the offense. Full stop. Section 340, Section 195, Inquiry as to forgery in document produced in court in order to make inquiry under the provision of Section 340. There must be some material to show that the offense mentioned under Section 195b has been committed. Full stop. Section 357 Order to pay compensation consideration for payment of compensation is different from payment of fine. It is necessary to probe into capacity of the accused to pay the amount and the purpose for which it is directed to be paid. Compensation imposed must be reasonable and not arbitrary. A fortiori, an inquiry, even in summary way, is necessary. In this regard, such a jurisdiction cannot be exercised at the whims and caprice of a judge. Prosecution under the Act may be contemplated as a measure of deterrence, but the same is never meant to be a prosecution. Magistrate cannot award compensation in addition to fine. When a fine is imposed, private party has no right to insist that compensation may be awarded out of amount of fine. Power to award compensation under section 357 is not an ancillary power. It is an additional power, a penal state in the event, different meanings are possible to be given must be construed liberally in favor of an accused, while the court shall give due weight to the need of the victim, it cannot ignore the right of an accused. In case of conflict, construction which favors the accused shall prevail while exercising appellate power. A person should not suffer imprisonment only because the conditions imposed for suspending the sentence are harsh amount of compensation. Not only must be reasonable one. Full stop.